Hello, welcome to this webinar on Mastering an Effective Dispute Resolution Clause. We are very happy to have you here for 1 hour for this lunch session. We are quite amazed that we are both here today because we had this wonderful SCC karaoke night yesterday. If you didn't join us, please do next year during SCC Arbitration Week next year. This webinar is, of course, part and the final part, actually, of SCC Arbitration Week. And we've been communicating focused in a focused way about dispute resolution in different forums this week. We've had 5 events. This is the final one. And a wonderful event at Nationalmuseum 2 days ago. I hope you will join us next year as well. If you have any questions during this session, please write them in the chat. We have a colleague who will do her best to answer the questions as we speak. If you have a question after the webinar or during the webinar that you would like to send privately to us, please send an email. We have our contact details on the website, of course. So the agenda for today's session is that we will start with a short introduction to SCC Arbitration Institute. Who are we? Why are you listening to us? And then we are going to go on and discuss a few different options when it comes to dispute resolution. What are the different methods that you can find in arbitration institutes worldwide? And after that, what you're all here for, the contractual clauses. How do you negotiate the best possible, the best suited arbitration clause or clause for mediation or some other type of method, of dispute resolution method? So that's the agenda, and please send us your questions during the webinar in the chat. My name is Caroline Falconer, and I'm the Secretary General of the SCC.
And my name is Madeleine Thörn, and I'm Deputy Secretary General and Head of Operations at the SCC. And let's start at the very beginning. The SCC was founded in 1917, and we've been an independent part of the Stockholm Chamber of Commerce ever since. We have been a reliable and stable partner for over 100 years, and we're not going anywhere. Quite on the contrary, we have been driving innovation in arbitration ever since. And I want to point out a few of our innovations. Already in 1998, we introduced expedited arbitration, followed by emergency arbitration in 2010. Fast forwarding to 2019, when we introduced the first SCC platform, a digital and cybersecure case management system, and we also have an ad hoc platform that we provide for arbitrations that are not administrated by the SCC, but still cybersecure and a really good digital case management. And we are very proud of our SCC Express. We are the only ones in the world providing this service, and in essence, it is dispute resolution in 3 weeks for a fixed fee.
So if it's new and hot in the arbitration industry, it's probably from Stockholm. And we dare actually say that we are probably the most modern arbitration institute, international arbitration institute in the world. And we're quite bold when we say that, aren't we?
We are, for sure.
So very short on the SCC. We are an International Arbitration Institute. We administer normally around 150 to 215 cases per year. Some years more and some years less. We're seeing an increased number of cases this year. And most arbitral institutions saw very few cases last year. It really follows the economy and the world at large. We see fairly large and complex cases at the SCC, and last year in 2022 we had an overall disputed amount of 1.6 billion euro, which is fairly big, I would say. if we have a look at the parties, where do parties at the SCC come from? The pictures you are now seeing shows you where the parties last year, 2022, came from, and you can see that the dots are scattered from all parts, more or less, of the world. The last 10 years, we've had parties from 87 countries in the last 10 years. So we are seeing more or less all the world at the SCC. And we also, of course, we work in English as well as Swedish, but also in a couple of different languages. Russian, we see a number of Russian-speaking cases, but also French. At some years we see Chinese cases, and we have had, due to our history when it comes to Russian and Chinese cases, we do see those languages quite a lot still.
But why do we really use arbitration? Why is this such a good method of resolving disputes? Well, some things that we would like to highlight is that it's fast compared to court proceedings. It's also fast compared to ad hoc proceedings, something that we showed in our recent dispute, contract disputes, construction disputes report. And it's also another benefit is that you have confidentiality for the arbitrators and the institute. This is, of course, something that the parties can decide if there will be confidentiality also between the parties. But for the arbitrators and the institute, there is confidentiality.
And if the parties want to have a confidentiality between themselves, what do they need to do?
That's a really good question, Caroline. Thank you. You need to include that in your clause, that there will be confidentiality also between the parties. So that's something that's really good to remember for the parties while drafting the clause. And parties may also choose their own arbitrators when choosing arbitration instead of, for example, court proceedings. So the parties can choose someone with the right experience and competence tailored for that specific dispute and industry as well, and sector in which the parties operate. And enforcement is another benefit when it comes to arbitration. Over 160 countries signed to the New York Convention, which then enables enforcement of the arbitral award. And another thing, going back to that, is faster proceeding in arbitration, is that it's not possible to appeal the award. You can challenge it on procedural grounds, but not on the merits.
Going back to enforcement, I just love the New York Convention because it's actually the most successful international convention of all time, having more than 160 countries abiding by it, including some of the countries you've probably never heard of, in essence. So if we have a look at the different services you can find at international arbitration institutes, including the SCC, of course, you can have you can resolve your disputes in an arbitration or in expedited arbitration if you want to have a quicker way of resolving it and less expensive also.
And what is the distribution? How many cases, more or less, are arbitration and expedited arbitration, would you say?
At the SCC, we've been very lucky to have had the SCC expedited arbitration for so long, since the mid-90s. So we have a quite good number of expedited cases, and around 25% of the arbitrations at the SCC are expedited, and 75% are arbitrations.
And then we also have the SCC Express, that you can have an assessment, a legal assessment, within 3 weeks for a fixed fee. And we also have emergency arbitrator, that's a decision within 5 days. Mediation, it is a negotiated agreement between the parties, and some other services at the SCC as well.
Why do you need to know about the different services? It's of course of interest to you when you contract, when you negotiate a contractual clause on dispute resolution. You need to know which services, which methods of dispute resolution to include in the contract. For some contracts, you only need a very a model clause for arbitration, which can be very simple. some other contracts, maybe you need a combined clause where you combine a couple of these different services. So arbitration, you can choose between 1 or 3 arbitrators. If you have a high complexity case, you see that the value of the case, the value of the contract is large, or the disputes arising out of the contract can be complex, I would suggest that you go for arbitration. That is also the case if you are, if you foresee that there will be many disputes under the contract. Maybe arbitration or expedited arbitration is the way to go. Expedited arbitration, it's quicker, it's less expensive. You only get one arbitrator. It is still an arbitration, so it's still enforceable under the New York Convention in more or less all the world. In some institutes, there's a value cap. So when the dispute is below a certain value, you will have to use the expedited arbitration at that institute. That is not the case at the SCC. At the SCC, the parties decide for themselves. So in your contractual clause, you need to decide when to go to arbitration and when to go to expedited arbitration. Some contracts with lower value and less complex issues, maybe you only need an expedited arbitration clause. If you go to arbitration or expedited arbitration, it will render you an enforceable award, and you can enforce it under the New York Convention in all those countries under the New York Convention.
But then if you have a low complexity case, and you can also say that it's not necessarily a low complexity case, but it could be a complex case, but that you can identify one specific issue maybe that could then, if that issue would be resolved, then the bigger complex case could be resolved, and then you can opt for either mediation or SCC Express. And the difference between the mediation and SCC Express, I would say, is that mediation, it takes a negotiation between the parties, and that the parties agree to a negotiated settlement, and it really takes that both parties agree on this, whereas in SCC Express you leave it up to a neutral, as we call it, an expert, a legal expert, to decide on the issue, and that expert will then render a neutral legal assessment within 3 weeks. So it can be both that the case is of low complexity as a whole, or that you can identify a specific issue. And this is a fast resolution, as we mentioned, 3 weeks for the SCC Express. Mediation can also be within a couple of days, and that's depending on the parties and how fast the parties reach an agreement. So that, I would say, are the main differences between the different services. And we are always happy, of course, to answer questions if you have any questions regarding a specific contract or so, if we have any pointers to other factors that could be interesting to discuss.
And we do get those questions quite a lot, so please send them in to us. One factor or one aspect of alternative dispute resolution, such as arbitration, we discuss quite a lot, is how long does it take? And at the SCC, we're proud that we are quite quick when it comes to resolving disputes. Disputes handled under the SCC arbitration rules, so either with 1 or 3 arbitrators. We try to resolve them within 1 year in general. And 67% last year were concluded within 1 year. So 67% within 1 year. Then there are a few dragging on longer, and where there's a need for much longer time to resolve a dispute. But we have 16% actually being concluded within the first half year. And that's quite good. And if you look at the expedited arbitrations instead, 84% were concluded last year within half a year. So within 6 months, 84%, and 20% were amazingly concluded within 3 months, which is really fast when you think about all the steps being taken in an arbitration, also in an expedited arbitration.
In an international perspective, how would you say that these numbers match?
We are very good when we compare ourselves to other arbitral institutions. And one reason for that is that we have a light touch administration at the Institute. The Secretariat, the SCC Secretariat, we try to turn around questions and contacts we get within 24 hours. And why are we talking so much about time? Because we are always, I feel that we are always talking about how long does it take. And we are always so proud that it's quite quick at the SSC. So why is that?
One factor is, of course, time in itself, because you say that late justice is denied justice, but also the cost is a factor that we take into consideration, because a cost-driving factor are, in fact, not the costs based on the administrative fee to the SSC or even the fees to the arbitrators, but in fact the counsel fees. That is the one most important factor when it comes to costs, and we can see that from 70 up to 85% of the costs of an arbitration in total is actually the fees to the legal counsel. So the longer the proceedings, the higher the cost for legal counsel.
And when you say legal counsel, it's not the in-house legal counsel attending this webinar. It's actually the law firm you contract. Yeah,
exactly. That is correct.
But another reason is also in very many disputes, time is of essence, since you want to the parties to the dispute would like to go on with their relationship or to end the relationship in a sensible manner.
Exactly.
So
go back to focusing on the core business.
Yeah, go back and stop working on the dispute, really. The reason you logged into this webinar, I guess, is to learn more about arbitration clauses and dispute resolution clauses, how to negotiate them in the best possible way. And the best advice we can give is please use the model clauses you find on the website of all international arbitration institutes. The model clauses are more or less the same. They look the same. And we are going to discuss the SCC model clauses today. But we can really recommend, please use them, because we are going to give you a couple of examples in a couple of minutes where people did not use the model clauses and it did not go well. If we have a look at the standard arbitration clause, the most simple form of an arbitration clause, you should probably see it by now. That includes a clear reference to what kind of dispute are you referring to arbitration. You should include the word arbitration in the clause, and the arbitration rules. Are you going to use the SCC arbitration rules? Make sure you have SCC's name in the clause and the name of the rules as well. That is really everything you need to have a proper, well-suited arbitration clause in your contract. So we are here to make you choose SCC arbitration in the future, of course. But there are a couple of other really good options out there as well. And I'm actually going to name a few of them. The top tier are Stockholm, the SCC Arbitration Institute. You can always go to ICC in Paris or in Switzerland, is where you usually see them seated, or London. There are differences between the institutes, and you can find more information about the differences online. But well, the advantages of coming to the SCC is very much that we are cost efficient and we are quick. We are quicker than most other arbitration institutes, and we are more cost efficient as well. So that is our main selling points, I would say, as well as being modern. We have a great online platform that your counsels or the law firms and arbitrators appreciate, and making the dispute easier to handle and more in a more focused manner, I would say.
Is there one difference to the ICC that you can mention in particular?
Yes, the time. It takes longer to at the SCC, and one reason for that is that they have two steps in the arbitration proceedings that we don't have at in Stockholm or at the SCC. They have the arbitral tribunal works with terms of reference, and they also, the ICC secretariat, they scrutinize the arbitral award, and that takes longer. We don't have that at the SCC, and there are very few institutes doing it the same way as the ICC. So when you decide on an institute, you need to have a look at how trustworthy is the institute. Will the institute still be around when you have a dispute? We see some cases, some disputes at the SSC with contracts from the 70s and the 80s, and we are still around, so we can still administer those disputes. But that is really an important issue when you negotiate an arbitration clause. Make sure you choose an institute that will be around when you have your dispute. You should also choose a seat for the arbitration, and the seat is not where you actually need to have your hearing. You can have your hearing anywhere in the world if you decide on that together with the other party.
And so would it be possible in an SCC clause to include a seat somewhere other than Stockholm?
Of course. You can have an SCC clause with a seat in Germany or in China or in we do see a lot of seats in other European cities, I would say, mainly. The majority of the SSC clauses we see are seated in Stockholm because it's good to... Stockholm is a very good place for arbitrations. We have low corruption in Sweden. You can trust the court system. If you challenge the award, the courts in Sweden and the Svea Court of Appeal in Stockholm, they are arbitration friendly. They will do their best to uphold the arbitration and the award to make it enforceable in the world. You also have, it's really good to choose a seat where you have a strong arbitration institute. Then you know that there will be good law firms with competence when it comes to arbitration. There will probably be good hearing facilities as well. In Stockholm, we have the Stockholm International Hearing Center. And very many of the law firms have hearing facilities at their law firms as well. And you should also think about the cost of legal representation. How much will it cost you to have a law firm from that country working on the dispute for a year or 2 years, depending on the arbitral institution you choose? So the main part is really find a seat where you can trust that the award will be upheld in the end. Otherwise, you will have gone through an arbitration and will not have an enforceable award, and that is really not good for any side in the dispute, of course. Another recommended addition we always try the parties to include is the language. So you can have an arbitration at the SCC with a seat in, for example, Germany, and the seat should always be a city. So Berlin, Helsinki, Beijing, for example, Singapore. And then you can have a different language. The contract, if the contract is written in English and both parties are English speaking, the arbitration will most probably be held in English. But please state that clearly in the contract, in the clause. It's really good to have for the future. And there is also a possibility to have the arbitration in 2 languages and to have arbitrators fluent in both languages for that arbitration. We do see at the SCC, we do see arbitrations in different languages, mainly in Swedish and English, of course, but also other languages. And if no one at the SCC Secretariat speaks the language, there's a possibility to have the arbitration in, for example, Italian. But then have the correspondence with the SCC Secretariat in, for example, English. But we do have personnel speaking Italian at the SCC, but still, that's a good example. And finally, very important, and something we see the parties actually miss from time to time, is the substantive law, the governing law. Which law should govern the contract? And it's one of the most important decisions the parties are taking in the negotiation, and this should be decided quite early on in the contract negotiations. It's not a question to decide around midnight on the last day when you are negotiating the contract. This can really alter the parties' positions depending on which law do you end up in. So, for example, you can have an SCC arbitration clause with a seat in Berlin. The language of the arbitration should be English, and the substantive law should be Swedish. That is completely doable. You can also do different continents. You can do a seat in New York, for example. You can have the SCC arbitration clause with a substantive law from Asia or a seat in Asia as well.
I find it so interesting that you can have the seat somewhere else, and you can also have the substantive law being certain countries' law, but then you have language that is different, for example, English, that is used more broadly. So that's something that we also mention for companies, if there are companies in a multinational contract, that they come from different countries, that when you negotiate, you can also take this into consideration, that if you will give some party a preference when it comes to the seat, you can have another preference when it comes to language and so on. So that's also something that to consider when you negotiate the clause.
Yes, it's really important. So you end up in an arbitration of your choice in the end. There's also a possibility to choose, if you have an arbitration clause referring the potential disputes to arbitration, it's possible to choose 1 or 3 arbitrators. If you foresee that the disputes will not be that complex and time is of importance to you in the future, then please think about the possibility to have only 1 arbitrator. And that is something you can add to the clause. And we already mentioned this, or you already mentioned this, but confidentiality. Just to have an arbitration clause where the arbitration institute has, of course, rules, and those rules have a section on confidentiality. That does not mean that the other party, the parties to the contracts, are bound by confidentiality. So you need to have your own confidentiality clause in the contract. That is, of course, standard. You see that in more or less all contracts today, but that is something you can't forget unless you want it to be public, of course. So we went through the standard clause. So are there any other clauses we have?
There are. We have several combined clauses, and one clause that is combined is the rules for expedited arbitration as first choice. And you see there that the first-hand choice then is the expedited arbitration, but depending on different factors, maybe the arbitration rules will be more suited to this specific dispute. So this allows for flexibility when the dispute arises. And this clause will then give the SCC the opportunity and discretion to determine, taking into account the complexity of the case, the amount in dispute, and other circumstances, that the arbitration rules shall apply instead. And this is something that we see a lot and that we can recommend. For example, if it is a contract that that is foreseeable that the contract will be used for many, many years, and it can be many different types of disputes, and there can be differences when it comes to complexity, and also the amount in dispute can vary a lot under one contract, then this clause may be recommendable. And the SSC can also decide, if it is decided that the arbitration rules shall apply, whether the arbitral tribunal should be composed of 1 or 3 arbitrators. We can move on to some other clauses, model clauses, and we have another combined clause where it's not the expedited arbitration that's the first-hand choice, but the value is what will be considered when deciding if it should be the expedited arbitration or the arbitration rules that are applicable to that specific dispute. And if the disputed value is below 100,000 euros, then the expedited arbitration rules will apply, whereas the disputed amount is higher, then it will be the arbitration rule. So this is also a way to distinguish between the expedited arbitration and arbitration rules, and allow both set of rules to apply depending on the complexity, which is usually implied by the disputed amount. And there is also an addition when it comes to how many arbitrators will be deciding the case, also depending on the amount in dispute. We also have model clauses for mediation. We have mediation separately. We also have a combined clause when it comes to mediation. We also have this for the SCC Express. So I would recommend you to have a look at our website and see the different opportunities that we provide when it comes to model clauses.
Do you have a favorite clause?
My favorite clause is the one that we started with, the combined clause with the expedited rules as a first choice. I think that takes into consideration lots of different factors that are relevant when choosing the right set of rules. Which is your favorite?
The same. No, I think it's a really good clause, because it's very hard to foresee the kind of dispute that you will end up in a contract, and well, it really foresees and the possibilities. It gives you the possibilities, and I'm not that fond actually of the value-based arbitration clause, because if you a quite small dispute when it comes to the value can be of great importance to the parties, and in that case maybe you want to have the possibility to have 3 arbitrators in an arbitration instead of expedited arbitration. So it really depends, and I like the combined clause with the expedited arbitration as a first step. But I also like the possibility to have the SCC Express as a first step of it. And that is not something we have seen that much yet. We launched 4 different versions of SCC Express clauses earlier this year, this summer. And we know that we have had a SCC Express case, and we know that the SCC Express clauses have been used in contracts, but I would like to see that used more in the future, because I think it's a perfect possibility for parties where you can have a need for quick dispute resolution during the business relationship.
I agree, and I heard it was really easy to negotiate, including the SCC Express as a first choice. So this is something that really we have heard so much from companies that there's a need for it really in business, and we have big hopes for the SCC Express being included more often in the arbitration clauses, and that will tailor the specific needs for the dispute to the methods that we provide.
We don't have any clauses for emergency arbitrators, and that is something we see a couple of times per year at most arbitration institutes. But why don't we have any clauses for emergency arbitration?
Thank you for that question. It is because when you include an SSC clause, it's already included. If you have the arbitration rules, if you have the expedited arbitration rules, it is included to have the opportunity to also request emergency arbitrator.
And that was actually the start of the SCC Express. We saw that parties were using the emergency arbitrator in a way that we didn't foresee in the beginning. That you could go to an emergency arbitrator to get a first assessment of the merits of the dispute. It took only 5 days, and after that the parties usually settled. So we didn't see them again in a later arbitration. And that was the reason for the SCC Express, where you, instead of 5 days, have 3 weeks. So some advice when it comes to arbitration clauses or dispute resolution clauses is that some problems we have seen when the disputes come to us is that parties have included escalation, mandatory escalation in the clause. So perhaps you have you include a statement that first the heads of the business areas need to negotiate the dispute, and after that the CEOs of the company need to negotiate the dispute, and after that you have the external dispute resolution methods such as SCC Express, mediation, or arbitration. The problem with mandatory escalation is that if you are in a conflict with the other party and the relationship is not the best, the other party or you could actually say that, well, this doesn't. This is not a negotiation. The meeting the business heads had, that did not amount to a negotiation under the clause. So quite quickly you can have disputes within the dispute. Did you actually comply with the steps in the escalation clause? Did the CEOs having a phone call for 10 minutes on a Sunday afternoon, did that actually amount to what the dispute resolution clause said was required for a negotiation? So we are very happy when you include escalations, steps in that where you can escalate the dispute, but don't make sure they are not mandatory, or if they are, be very clear what is considered, what is required for those steps. Another issue I know that we have discussed between different arbitration institutes that can be quite tricky is actually when you include a very detailed regulation on how the tribunal is going to look. So we have seen that, well, the parties have apparently had one person in mind when writing these requirements, and have not actually given the name, but have given that much details about the arbitrator to be appointed. So it's impossible to find someone else. And maybe this arbitrator is not the best for the case. Maybe that arbitrator is not working any longer, and maybe the arbitrator is busy. Doesn't have the availability for resolving this case. So we always prefer to have free hands as possible to appoint arbitrators. We are we know the arbitrators out there. We know both the ones in Sweden, of course, but also very well all the international names working as arbitrators. So, and we know availability, previous performances, and how they probably will perform in different arbitrations. And we always try to balance the tribunal. So we try to make sure that you have the best possible tribunal. If you have three members, how do they complement each other?
What factors do we take into consideration then, would you say?
Very many factors. It's not an easy, this is not easy, and it's one of the most important decisions we make in an arbitration. But one factor is, of course, language skills. They need to be able to work in that language. That can be very easy for some cases, harder in other cases. Qualification. They should know or know enough about the law they are going to apply to the contract. That doesn't mean that you need to have a qualification in Swedish law to be able to handle the case under Swedish law, but still it's good to have some knowledge about it. Experience from the business sector. It's really good if you are handling an arbitration in the energy sector, that you have some understanding of the energy sector, that you have some understanding of the construction sector, and so on. And not only some, quite a lot. We have quite high requirements, for quite high standards for our arbitrators. But also make sure that we have age. We have people being able to handle the case. If it's a technology heavy case, that might be an issue we take into consideration. And finally, availability is very important. Since we are proud in having quite quick arbitrations when possible, it's very important for us to have arbitrators with availability so that they can actually handle the case when they receive it.
And as you mentioned, we focus a lot on the composition of the arbitration tribunal, the arbitral tribunal, and see that they will work well together. Do they complement each other? Do they have in total the experience and the different maybe aspects that this dispute will require, so that it will not only be three identical arbitrators, but a more rounded arbitral tribunal as a whole?
Of course. And then we are always proud to when we speak about the diversity, we try to get both female and male new blood into the arbitrator pool. We try to make sure that we have the best possible arbitrators out there. We are. So that's very important for us to be able to appoint the best possible arbitrator. If I go on, I'm sure I missed some of the aspects we take into consideration. You find more information about this online on our website if you want to look into how we appoint arbitrators. Something else we've seen that we don't like in arbitration clauses is multi-forum clauses. You could have a clause saying that if company A starts the arbitration, it will be started at the SCC under the SCC arbitration rules. But if company B, the other side, starts the arbitration, it will be under the LCIA rules seated in London. That can be very well if you only have one dispute on the contract. But if you have a counterclaim or two arbitrations started from each side, you will want to have those together at the same arbitration institute, and you can then have cost efficient a much more cost-efficient arbitration. You can have the arbitrations joined, for example. So we dislike multi-forum clauses, so please try to avoid them. And if you can't find a common ground with the other party when you are in these negotiations, it's better actually to not have your home, your own, if I may say so, arbitration institute. Please choose a different neutral institute, but have all disputes go to the same arbitration institute. Something we see quite often is also different arbitration clauses or different dispute resolution clauses in different contracts in the same structure. So you could have several contracts between the same parties or between the same company groups. They are part of one structure, but some of the contracts are referring to court litigation, some are referring to arbitration at the SCC, and some might be referring to arbitration in New York, for example. And that is also the same problem when you have a multi-forum clause, so that you can have several parallel proceedings where one is in a state court, one is at arbitration in Stockholm, and the third in New York, and you can't join them, and they are progressing in different speed. So that can be really problematic for you in the end, and will drive costs for you, costs and resources.
And this is more common than you may think, and it always creates lots of problems. So I would definitely say that please avoid it.
Yeah. Our favorite fault, if we may say so, pathological clauses. So clauses where parties really did something completely wrong, and we have a few very very good examples of this. Something we've seen a couple of times is that maybe you use the model clause from an arbitral institution, but then you change the name of the institution to something else. We have seen cases being referred to us as the Court of Arbitration in Stockholm. That was handled under the SCC rules, so we had jurisdiction under that clause, but there is no Court of Arbitration in Stockholm. So if you mean the SCC Arbitration Institute, use that name. We have also seen a mix of different model clauses out there. So maybe you have a clause referring to the ICC, and you just add some language from the SCC clause. This clause, this example, is a couple of years old, and it says, I'm going to read it since it's quite a lot of text. In the case the parties fail to reach an accommodation, any and all disputes or claims arising out of or in connection with the contract shall be governed and resolved exclusively by the International Arbitration Court in Stockholm, Sweden. There is no such court. The parties agree hereby that international law shall apply in case of settlement of any disputes arising out or in connection with this contract. There is no international law in that aspect either. This contract shall be governed by the regulations of the International Chamber of Commerce, Paris, France, with regard to force majeure circumstances. And I guess this clause wasn't negotiated by lawyers, because there are so many mistakes in this clause. But please make sure that you don't write this clause again. And a final example for the Swedish speakers out there, dispute in Swedish is twist. But a twist in English, it's something completely different than a dispute. But we had this wonderful clause once, in case of twist, the Arbitration Court of Stockholm shall. And if you have this was handled under the SCC Arbitration Institute. since if you have an arbitration under Swedish rules, Sweden is an arbitration friendly country, and we are trying to refer the parties to arbitration where we can. If you have this clause, you can't go to courts. Of course, at the SCC, we're trying to administer the case for you. But really, you had one job. Make sure you do it properly.
So I would like to recommend you to check all the model clauses that we mentioned, but also please join us on LinkedIn, follow us, me and Caroline, and the SCC to stay updated on our latest news, activities and reports.
Please sign up for the SCC newsletter. It's monthly, so you're not going to get too many emails from us. But we try to communicate on both issues when it comes to contract negotiations, but also news in the arbitration and then dispute resolution area. So we try to find content that is of interest to all of you.
Thank you very much for joining us today, and we hope that you have some new insights when it comes to negotiating dispute resolution clause. Please let us know if you have any more questions. Reach out to us after this session, and thank you for your attention, and we look forward to staying connected.
And we hope to see you all on LinkedIn and in our newsletter, of course.